Civil litigation in Ghana on average lasts 7 to 9 months, but that can be dragged out, for instance, if there are interim hearings, which means either side can present legal arguments or points of law, or they're contesting something. So that can ordinarily sort of drag out a trial, but on average it should be 7 to 9 months for any sort of civil claim in Ghana. So once you engage a lawyer, the best thing to do is to engage them by sending them all the information, all the evidence you have, as well as have a meeting with them, and they can review that in order to decide what the terms are of engagement. And once that is decided, then they will draft a written statement of claim, which summarizes who you are, what your claim is, how the incident or the matter evolved, when it happened, and your reliefs in terms of the reliefs you're seeking from the court, and whether you're also asking the court for costs in terms of the legal amount that you're spending in order to bring the action. And then what happens is that service is normally effected as soon as it's filed. In terms of the statement of claim is filed, service is normally effected within 3 days or so. And if the defendant is out of jurisdiction, then your lawyer would ask for special permission in order to serve that defendant out of jurisdiction, particularly if it's an international company with a headquarters abroad or no base in Ghana. And if the defendant can't be served, then through the normal means of taking the statement of claim to their office or to their home, then again the lawyer would ask for special permission to serve via WhatsApp or to just post that statement of claim on the court premises. And what would thereafter happen is that a defense or defense and counterclaim is then filed by the other side, and if they fail to do so within a number of weeks, then the petitioner or plaintiff can go for default judgment ordinarily. So after exchange of pleadings is the application for directions, where you prepare, or the lawyer prepares, a comprehensive application for directions to guide the court in managing the case efficiently, because ultimately it's always about your lawyer's strategy, it's about time management, it's about looking at the civil procedure rules and seeing how that fits into your client's case in order to succeed. And next comes the preparing and exchange of witnesses or expert evidence. So this stage involves identifying the key witnesses, preparing their affidavits, potentially engaging expert witnesses to provide specialized testimony. And it obviously involves meticulous investigation, careful witness preparation, and strategic planning in order to present the best case possible on behalf of one's client. Next is the disclosure. So, disclosing information, but not disclosing everything, so that you're strategically managing, the disclosures within the case. And that is relevant documents and information between the parties, as well as, one thoroughly reviewing the client's information, deciding what is privileged, and strategically preparing what should be disclosed in terms of what the other side should have, and so forth. For the case management conference, this is like a pre-trial stage that it's determined whether there's going to be a settlement. It's also determined, if there's not going to be a settlement, how long the case will last, in terms of the judge will manage the timetable for the case, and discuss procedural matters as well as deadlines, etc., so that it's not a free-for-all in terms of the case has some end in sight, and even the witnesses that are to be called, if all witnesses are needed, and different things, that's what normally happens at that stage. For the final hearing, it's just literally cross-examining the witnesses of the other side. It's presenting arguments, it's meticulously preparing and having a strong understanding of the law, as well as how to present persuasive arguments, so your side wins in essence. And then after that, it's concludes in terms of the judge will then decide the monetary amount to be awarded in the civil trial. But litigation in Ghana is not as daunting as one would imagine. In terms of, there is a timetable for parties to bring forth witnesses, etc. The only thing that can stretch out a case is the interim hearings, and our laws very much mirror UK law in terms of our civil procedures. And, the only exception is perhaps for maritime law. It's the same sort of, one has to go to the High Court as opposed to some sort of specialist court, etc. So I hope that's been a good summary for you in terms of what civil litigation entails in Ghana.